Sure.
Yeah, I see no problem with that.
All right, I heard someone talking, but it just came through as garbled.
I guess it was me, Joe. I said I have no problem with that.
And this is John. I also, Summerlot, I also said yes.
This is Patty. Can you hear me?
Yes, I hear you, Patty. I think we all can hear you.
Okay, it got really quiet. I thought maybe my sound went away.
We were waiting.
I got kicked out for a second. Has anyone heard from Yvonne to say that she wouldn't be attending?
I have not.
I did not hear from her today.
I just sent her a text message, so. Someone called in? Someone is dialed in from a phone? I don't know if that's her. Yvonne, are you on the line?
I think that's Linda.
Okay. Should we give it till 5 past, or should we just go ahead and start it?
I think we should go ahead and start it. I move that we start the meeting, if that's how we should do it.
I
All right.
second that.
All right, meeting is being called to order at 6:04. John, could you call roll call?
Yes, sir. Chair Horkley,
Close enough.
Yvonne Tucker, Evelyn Stevens,
Here,
Patty Callicott,
Present.
John Summerlot,
Present.
President Franklin,
Present.
Town Attorney Kevin Best.
Evening.
All right, we don't, well, depending on which agenda we're going off of, based on the one that John sent out, I'm gonna suggest that we first have an item to discuss the agenda. And then in that meeting to discuss the agenda, that we move the legal discussion earlier and push the review of minutes later. Any objections?
I have none.
I have none.
No objection.
Okay. Yvonne just texted and said that she's stuck in another meeting, won't be able to make it. Okay, so basically my big concern is trying to ensure that the Board of Supervisors of Elections complies with the town law. And my read on it is that we are responsible for the running of the election. And, you know, we haven't delegated that authority to someone else, to the town clerk or the town president. I'm not even sure that we can, although it does say that we may direct town staff to do stuff. So I'm not happy when, you know, things regarding the election are being done by people who have not been directed to do so by the Board of Supervisors of Elections. So, does anyone else have any comments on this?
Joe, this is Patty. I believe that everybody should pretty much stay in their swim lanes. That's directed by the charter. Otherwise, we will have conflicting agendas, conflicting duties, and it'll just end up being a mess. So, I mean, I don't care, honestly, who takes the responsibility, but I think the swim lanes need to be defined. And we've gotten a list of things that need to be done. And if we just need to generate a document that says who's going to do what and where and who's getting the direction from whom, that's fine. But I do believe the charter does give most of the responsibility of delegation of tasks to the Board of Elections.
Any other comments from Evelyn or Jay?
Well, this is Evelyn, and my comment is only that I understand your point, I understand Patty's point. But I also am unclear about the declaration of emergency order that allows the election to be moved. Now, is that the real argument here? Or is it that are there more than one argument, meaning that we feel that the BOSI should have autonomy and that the Board of Commissioners should not interfere with the task involved with running the elections? Now, this declaration of emergency order to me is not a task, and am I incorrect in that? And I'm asking this question of the town attorney. Is this something that is outside the parameters of the Board of Commissioners?
Mr. Chairman, would you like me to respond?
Yes, please.
All right. So good evening, everyone, and particularly for the commissioners, or I'm sorry, the supervisors that I have yet to have met. My name's Kevin Best. I'm the town attorney. Been the town attorney for 12 years, a dozen years, a long time. I was hired back when Joe Herkley was a commissioner, I believe, with Steve Sonnet and another guy named Lennig. So it's been a long time. Let me talk in generalities about the role of the Board of Election Supervisors vis-a-vis the Board of Town Commissioners. As you know, the Board of Town Commissioners is the governing body. The Board of Election Supervisor is an instrumentality or an agency of the town government under the law and under the charter. The charter is the supreme law of the town. It's the organic fundamental law. It cannot be superseded by an ordinance or a resolution of the Board of Election of the Board of Town Commissioners. The charter is very clear that there are certain duties and responsibilities, and that's evident why that's important, due to the propriety of having elections be insular and non-political. You have this body or group called the Board of Election Supervisors. They exercise mostly administrative function. They exercise no legislative power whatsoever. Nor do they have rulemaking authority, which is commonly found in municipal charters throughout the state of Maryland. Your town is a bit unique in that your Board of Election Supervisors has zero rulemaking authority. You do not have the authority to make rules and regulations for the conduct of election. That's something you can recommend and put together and give to the Board of Town Commissioners to approve. And that will be your guidelines or your rules, if you will. If they're non-binding guidelines, you're certainly, or tabletop procedures, you're certainly free to make those unilaterally as your own. And I will say that the town over the years, and the town has been incorporated by the General Assembly of Maryland since 1870. So the town, I think it's the second oldest municipality in Prince George's County, been around for a long time. And you all do have a paucity of rules and regulations for the conduct of your elections. I will say though, you have an article, if you will, in the charter that governs elections and registrations, and you do have ordinance 2001-2, which is a ordinance to regulate and provide for the conduct of voter registration, maintenance, registration records, conduct of elections, certification of election results, and penalties. So you do have some meat on the bones in terms of an ordinance that was approved in 2001 by the Board of Town Commissioners. And that's a very good thing, because it wasn't that many years ago that I did not know you had such an ordinance. It was a Johnny-come-lately ordinance for me, but I've never had any issues over the many years that I've served in town as a town attorney. Had very few issues over the years with the Board of Election Supervisors. No complaints, no problems. As you know, as town attorney, I not only am legal counsel to the town as a whole and its governing body, the Board of Town Commissioners, but I'm legal counsel to all its agencies and boards and commission as well. So you all, yes, you are an independent body in many ways, but you can seek legal counsel from me. And there hasn't been a lot of that over the years. And this is probably the first time I've sat with the entire Board of Election Supervisors. Okay, so let me go on to another matter, because it goes to this issue of what is the lane, or what's the bailiwick, what's the travel lane that's reserved for the Board of Election Supervisors, and what is the domain or responsibility of the Town Board of Commissioners. Like I alluded to before, that the Board of Town Commissioners' job is to, and this is found in the charter. Just bear with me a moment. Under section 82-34, the Board of Commissioners shall have the power to provide by ordinance in every respect not covered by the provision of this charter for the conduct of registration, candidacy elections, prevention of fraud, connection therewith, and recount of ballots. So anything the charter doesn't put meat on the bones on, doesn't give guidance on how to conduct elections, is something that can be promulgated by ordinance by the Board of Town Commissioners. By the way, let me tell you something. A lot of people are of this false notion that you all can just go crack open and look at the state election code, and anything it says on the election that is silent in your rules and regulations on the conduct of elections is governing you or governing your actions. The answer is false. The state election code does not apply, and this has been opined and decided by the Court of Appeals of Maryland, the High Court of Maryland, many, many times. It's settled law that for municipal corporations, the state election code, except with a few exceptions, does not, I repeat, has no authority, no binding effect on municipalities. There are a few exceptions, but I won't talk about those right now. So, and this is where we come into who gets to set the date of the election, of a special election. Your charter is somewhat unique in that it's silent. It does say the conduct of elections is the responsibility and authority and bailiwick of the Board of Election Supervisors, no doubt about it. The commissioners have no business meddling into your administrative and implementary affairs with the conduct of elections. That's your job as election supervisors. Their job is only to legislate or approve your rules and regulations or ordinances dealing with the conduct of elections and registrations. They certainly can do that, but they're not to meddle. And your charter is silent. It does have a provision that says when a vacancy occurs, an election will occur between 30 and 45 days. However, it does not state who's to declare the, I mean, it does not state clearly and expressly how the town goes about declaring the vacancy or sitting on their hands and waiting a few days or whatnot. So when Ms. Penoyer, Mayor Penoyer, decided not to qualify for office last December, a vacancy occurred. And that means the language of the charter kicks in and you hold an election 30 to 45 days later. And that was declared and set by a joint emergency order / resolution of the governing body as to the date. Again, the charter is silent on exactly when an election or special election is scheduled. So that was done by the Board of Town Commissioners in December. And then because of any number of reasons I need not get into too far right now, unless you want to talk about them later, there became known to everyone there might be a need to delay or postpone the election that was set originally for January 25th. So the issue is, does the Town Board of Commissioners or the President have the authority to declare that, to order that change in the date? And the answer is yes. Why? Because as to the Board of Election Supervisors, it does not expressly state in the charter you have the authority to set that time and date. Whereas there is an ordinance that gives the President expressly that authority during a health emergency or any other catastrophic emergency. And it's found in Emergency Ordinance 2020-04 that was passed on March 24th, 2020. And it states in section 4 of that ordinance, it's a standalone ordinance. In subsection A, item 22, it states, and the President, bear with me, says in subsection A, upon executive order of a civil municipal emergency by the President, and during the existence of such civil emergency, the President may, in the form that meets the requirements of this section, make and proclaim any of all the following orders. And there are numerous orders or emergency actions the President of the Board of Town Commissioners can impose during a COVID-19 or any type of catastrophic emergency, including item 22, an order to derogate express charter or ordinance provisions for conducting or postponing a municipal election, or to prescribe the method of conducting a municipal election. So I do not think that this order, most recent order promulgated by the President, which is Emergency Declaration or Declaration of Emergency Order 2022-01 that the new mayor, Sarah Franklin, just put out, I don't think that runs afoul of the charter. Because again, the charter does not expressly delegate to the Board of Election Supervisors when to schedule elections. Also, Ordinance 2001-2 is silent on the matter. And so the Emergency Powers Ordinance is clear on the matter and states that that is something the President can schedule. By the way, the President basically, during an emergency, stands in the shoes of the entire Board of Town Commissioners and has the ability to promulgate ordinances. Essentially, that's what's happening with the Emergency Powers Ordinance. However, according to that same ordinance, it has to, any order promulgated by the President, also known as the mayor, has to take that order back before the full Board of Town Commissioners for approval. Otherwise, within 30 days, the order or emergency order will lapse. Excuse me. So that's enough said on the interplay between the charter and some of these ordinances involved. And I hope I've answered the question who I think has the authority to establish and set election dates, particularly special election dates. Now I think the issue I'd like to address is this issue that Chair Herclay raises as to whether it's mandatory that you have an election within 30 to 45 days of a declared vacancy.
I think you've established that, and that's some of what I was trying to get when we had our phone call on Thursday. I wanted to know what the legal justifications were to make sure that the Board of Election Supervisors, wasn't going to get screwed in this whole thing, because we need to make sure that we do our duty. And it sounds like we do have legal justification. And so I would request that any resolution or ordinance or whatever that has to be declared, use that language as justification and not the issue of cost or, whether or not that shall is just a suggestion, and stick with that, because I think that is a very strong justification. But it's
well, I mean,
the first time hearing
let me
that.
clarify. Let me clarify that, Joe. And this is the thing, because the charter is very clear in section 82-29 with the catchphrase of special elections. It says the special election shall be held not less than 30 days and not more than 45 days after the vacancy is created. So, if you go to the day of swearing in back in December and you count 45 days, we're going to go beyond that, particularly with this extension. Or this postponement of the election into February, the last week, I believe, or third to the last week. It certainly does not comport with that language. However, and this is the point, this is the big point, I want you all to listen very carefully, is based on my legal opinion, that language is what the law calls as being directory and not mandatory. Normally, when you find shall in a statute or ordinance and the words that follow, that's mandatory. You gotta comply with it. And typically there'll be a penalty clause in that ordinance that if you violate that shall command, you will have to face a criminal, typically a criminal misdemeanor or a fine or a municipal infraction penalty. However, the courts have many times, particularly Maryland and other states, have decided and held in cases where they have applied the rules of statutory construction and discerned, even though the word shall is used, they have come down and said that means it's directory. What does directory mean as opposed to mandatory? Directory means may. There's discretion. And I would say, even though it does have the word shall in section 82-29, a court in Maryland, the High Court, Court of Appeals of Maryland, would come down and say that shall means may. And that's because there's plenty of case law to support this. And the Supreme Court of the United States of America has held that whenever the word shall is found in the statute as applicable to the government, and there is no penalty clause associated with that use of the word shall, it's considered to be directory, meaning it's discretionary. So in my legal opinion, as the chief legal officer of the town of Upper Marlboro, that is my opinion on the proper interpretation of section 82-29. And last I checked, no one else in the town government that serves the town government, either on the Board of Town Commissioners or the Board of Election Supervisors, has a law degree or is the appointed town attorney. And so, you all have a fiduciary duty to take legal advice. So I'm asking you to take that and accept that interpretation going forward. And so let me go. Yeah. Go ahead, please.
I have two concerns with your, argument. One is, you said when there are no penalties, and yet the charter does provide for penalties. Now, you've later said, in our discussion on Thursday, that those aren't actually allowed to be there. And in my discussion with the state's attorney today, he hadn't heard that argument before. So I'm still not sure where it falls.
Oh, wonderful.
The other argument
Let me answer
about
that,
the
please.
shall, okay,
Let me answer that one aspect, Joe, before we get too strung out. First of all, the state's attorney, God bless them, they're not municipal attorneys. Municipalities are unique creatures, and it's an art in and of itself to practice law dealing with municipalities, let alone other local governments. So if the state's attorney has not heard of this doctrine of law, fine. I don't know how long he or she, if it was the actual state's attorney or an assistant state's attorney, but God bless. Let me say that section 82-35 penalties of the town charter, in my opinion, also, I'm going to give an opinion on section 82-35, is a nullity. It has no force and effect. Why? Because the High Court of Maryland, again, for well over 30 years or more, has long held that penalty clauses or penalties in charters, municipal or county charters, are not permissible. They're not appropriate charter language, because a penalty that affects human behavior and carries a penalty that could deprive someone of their liberty or property is not appropriate for a municipal or county charter. That's the authority, that's common law in Maryland. And I would not be surprised if the state's attorney never heard of that, because their job is to prosecute the criminal law. Their job is to be trial litigators in criminal law, not to become experts in these civil creatures known as municipal corporations. So I'd ask that you, particularly since I am the appointed chief legal counsel, to defer to my opinion and not the opinion of the state's attorney or assistant state's attorney. Go ahead, Joe.
Yeah, so the other issue is in 82-22 duties, they specifically mix both shall and may, because they say the Board of Supervisors of Elections shall be in charge of the registration of voters, nominations, and all elections. The Board of Supervisors may appoint election judges, clerks, or other employees to assist in any of its duties.
Well, I don't see anything out of order or conflictatory or problematic with the use of the word shall and may, and the differentiation in the use of shall and may in section 82-22. It's basically saying that the bailiwick of registration of voters and nominations is the job of the Board of Elections, and really no other entity or body. Whereas the Board of Election Supervisors has, in the following sentence, has the discretion to appoint clerks and other employees. These are like adjuncts or assistants to the supervisors. So, you know, the supervisors don't have to be at the polls administering and running the election. Don't have to. You can have these other animals, clerks and other employees that can assist. Normally, you'll find in this same provision in other municipalities a provision that says the compensation for those other clerks, judges, and employees would be determined by the governing body, or some words to that effect. Go ahead, Joe.
There's a statement that the compensation of the Board of Supervisors shall be determined by Board of Commissioners. There is no such statement in the charter that I am aware of about election judges or clerks. I mean, we've always, until this most recent election, we have not had election judges who were independent from the Board of Supervisors of Elections in all of the elections that I've been involved in. And we've just used town employees to assist us.
Yeah, okay. Well, the difference is, as a supervisor, you're an appointed official. You take the oath of office. You're exercising as an appointed official part of the sovereignty of the town, whereas that may not be deemed the case with these other judges and clerks. And I think the governing body of the town, the Board of Town Commissioners, has the discretion to compensate these other appointed helpers, if you will, of the Board of Election Supervisors, because the charter is silent on the matter. Go ahead, Joe.
Yeah, and well, the fact that they were employees, they had been doing it in their own time up until this last election when Jay served as an election judge, but was not a supervisor. And I don't know how they were compensated relative to the rest of us. I did not get involved in that aspect of it.
Okay, well, we can talk about that some more as we go along, because I'm not sure that's right on point with some of the main issues of this meeting at this
Well,
time,
it's-
but
Basically, my concern is this, I mean, in duties, if you strip out the, if you take the list, because there's the first sentence has a list of 3 things. The Board of Supervisors of Elections shall be in charge of, strip out the first 2, all town elections. And it's, in our discussion on Thursday, I thought that we had worked out an agreement that the Board of Election Supervisors would have some discussion with the president on the language and scheduling for this upcoming, for this proposed move of the meeting or of the election. And then that didn't happen.
to be
And
quite
so
frank with,
Well, it's just-
Joe,
sorry.
Joe, to be
Go
quite
ahead.
frank with you, when I had the discussion with you last week, I assumed that very night, I think it was last Wednesday or Thursday night, that there would be a meeting, or the next night, Friday night, that there would be a meeting either jointly between the Board of Town Commissioners and the Board of Election Supervisors, or just jointly between the president, mayor, and the Board of Election Supervisors. That didn't happen, and that changed, and I'm sorry that didn't take place. But it's really crying over spilled milk. It's not a big to-do. Why? Because if you all tonight decided absolutely no way you wanted to have the election move to February 22nd, that's fine. The president of the Board of Town Commissioners has the authority essentially to write and approve an ordinance at a moment's notice. She has emergency powers. We are in a COVID-19 emergency. She has almost the
lost
same
audio.
powers. Who has?
Anyone else
Who
still
has
there?
lost audio? Mr. Chairman, what'd you say?
I lost audio.
Okay. What I was saying is,
I'm getting a connection unstable message.
what do you want to do?
Let's try to continue so long as I can hear you.
Okay, so basically I was saying the president, the mayor, at any time can promulgate an emergency order without the consent of anyone. She unilaterally has that authority in a COVID-19 or health emergency or any other type of emergency. So if you disagreed or adamantly are opposed or do not wish to ratify the decision of the president to move the election to the 22nd, let's hear it. And we'll move it if you have good reason, fine. But in my opinion,
At
the
this
mayor.
point, my issue is
Go ahead.
I still haven't seen a proposed schedule. I asked for a proposed schedule, of when the registration dates were going to fall and stuff like that. And, we just got this order without it. And so I still don't know if anyone has drafted a schedule to try to figure out, are we going to comply with the necessary, the deadlines are going to fall such that we can get this done cleanly.
Well, Joe, my answer would be, have you read Declaration of Emergency Order 2022-01? Because it lays out, it may not lay out all the milestones you think are appropriate, and you are free to adopt them for yourselves and apply them, or if they're mandated by law, maybe another order has to be promulgated. But basically, referring back to Emergency Order 2022-01, it states in the and be it further resolved clauses that the written statements of candidacy and nominating position are to be filed the first Monday in February, which is February 7th. And then, it gives the election date for Tuesday, February 22nd. And it has modified election procedures to help with COVID-19 issues. So if there's anything else left that would be tantamount to a ordinance provision, feel free to propose it, because the mayor has the power to put it in place immediately. But I'm not sure that's the case. I think you have plenty of law to go forward from here on with the new election date and the new deadline for filing certificates of nomination to move forward. Correct me if I'm wrong, Joe.
I'm trying to work through, I mean, we have 20 some dates that I've got to deal with, and all right, what's the first month? Okay, so the first Monday in February, February 7th, would then move the requirement for notice back to,
I think you're talking about a charter provision, right?
right, there's a charter provision that says that we have to give notice 2 weeks before.
Okay.
So if we
So
move it to
2 weeks.
7th, that would be the 18th
Today.
today.
Well,
And that's why we needed to get this resolved last week.
okay. Well,
I'm not sure John can kind of say whether things have been posted or not at this point. You know, we just couldn't have a meeting that complied with the Open Meetings Act last week, especially with a lot of the way emails were coming across at the town clerk and in general. So that was a big barrier.
So after the letter that I was sent today, part of the reason that I have been upset about this is because there seems to be a lack of urgency in trying to get notices out and other such that we need to comply with. And I don't know how many times I have to repeat it to try to get that point across. And it's upsetting that I should need to point it out over and over again, and that, you know, we had information up on the website that had not been reviewed by the Board of Supervisors elections that gave bad information.
let me
I
ask
mean,
you a question.
Yeah.
When would a newspaper of general circulation in the town of Upper Marlboro accept and publish a notice? Would last Thursday been the deadline, or would it be some other time?
So my understanding is that right now, the only newspaper that publishes is on a Thursday. John, is that correct?
That is, and we sent the ad over there today, and they're gonna get it in this week, from what I was told. So for the February 22nd deadline, or the date change. We also have updated the website to reflect the February 22nd date, according to the DOE that went out. We've also updated, we have some posters we're putting on sandwich boards that are going to go out as well. So things are happening, and we are getting that stuff done in a timely manner.
So is it fair to say there will be at least 2 weeks notice in a newspaper of general circulation advertising the election date on the new date? Is that correct, Mr. Clerk?
That is correct.
Okay, next
Or
issue.
am I looking at this wrong? Oh. Wait, February 7th. It can't be February. Okay, February. Okay, so it's the 24th is the deadline that we need to have it posted. Okay, then. All right. So we
Yeah,
will.
it's
be able to provide that.
election, not certificate of nomination or petition. It's election that you're giving notice of. So
No. We have to give notice of every registration date. And because that they call the putting in your letter, registering as a candidate, that is a registration date.
I don't know about that, Joe.
Well, in
Registration day
practice,
means registration day means registering as a voter. I doubt that it means
okay, so that,
candidacy
Can-
day.
so
or
that
Can we
whatnot.
is-
resolve this issue just by moving the candidate registration date to the 14th?
so the problem is that if you move it to the 14th, that gives us less time to deal with absentee ballots and getting the ballots printed in the first place. Because right now, there's about a 2-day delay before we can get it because of this setting of the ballot order thing. If we get rid of that, there's still a 1-day delay. So we wouldn't be able to get it, start printing ballots until the 15th. And that puts us really tight to get them by the 22nd.
Well, but we already, well, okay. So I think one of the other issues is there's a budgeting issue. And so that's coming up later in the meeting. And I won't be here for that part, but if we print the ballots in-house, we maintain a lower cost and it allows us to be more flexible with the registration deadline because we can start printing as soon as you guys finish.
So it does not lower our cost, because if an election supervisor is printing the ballots or supervising the printing of the ballots, it takes time, and that is time that would be paid to them that would eat away any cost savings. I also used to work in a print shop, and printing it in-house is risky because what happens if our printer starts acting up or stuff like that, whereas professional printers can switch to a different press. There's also the issue of the perforated paper that was selected. It has so many perfs on it that it's going to be very difficult to ensure that all of the ballots look identical. And, we don't want to, there are issues with being able to identify ballots. And so, we need them trimmed cleanly.
So staff could do the printing. So a supervisor wouldn't have to stand by the copier, but you all could inspect the ballots when they were completed. That would minimize that amount of time. If there's other printing options, that's fine, but let's not create deadlines on ourselves that add stress when we can take it away by simply doing things in-house or in some other way. So that's all I'm asking that you guys consider.
So it's a horrible risk to do the printing if we had 2 weeks, sure, but just replacement paper, if they send us the wrong paper the first issue was, the paper wasn't going to show up until the Friday before the election, unless we spent, $40 in shipping. And that's horrible. Just the fact that we basically had the weekend to get the ballots printed, and if something went wrong. So we're still, we might have the paper ahead of time and be able to test it, but what if, our tests find that, look, this doesn't go through our printer easily.
So I don't want to get too in the weeds with this because I am an elected official and this is like more into the details, but I just want you guys to have that information and be able to think about it in a more creative way so that we can meet all the deadlines and folks can be not stressed. And then also, obviously, the Board of Commissioners needs to ratify my emergency proclamation at the town meeting. So if there is, wanting to discuss the dates or change the dates, then that's a great opportunity to do it. And I can go forward to them with that. So.
Well, if we can get everything in the paper for this Thursday, then, I think we're okay to set the date as the 7th, but we need, I mean, there needs to be, the town did a press release on, hey, 4 commissioners were sworn in. It didn't do a press release on, hey, there's going to be a special election. And that kind of disturbed me. We need to make sure that the citizens know there's an election, and I'm really uncomfortable because I mean, at this point, it's less than a week from when the election is supposed to be. So we need to have like signage up on the town hall for, should anybody show up next week.
We also will have our constant contact that will go out this week that can advertise it as well.
Okay, and can we make sure that it is the first item and it's not buried among whatever other press releases?
Yes, usually with constant contact, I usually always make sure the campaign or any election items are always usually at the top for that reason.
Okay.
Just because I want to make sure we're being thoughtful with Kevin's time, are there any more supervisors who have questions for Kevin? And then also I'm going to have to leave in about 10 minutes. So for me as well.
So I've had my hand up for a while. I wanted to question, and I'm going to go back to the may and the shall. If you go through the charter, there are 289 shalls. Are those all now considered mays?
Well, my answer to that, it depends.
And
It's almost
let me
here.
caveat that with,
Yeah,
there are also 138 mays.
yeah,
And it appears to me that this charter goes back a very long time when must was never an option and wasn't considered a new way to say shall. And I believe the intent of shall, when this charter was originally written, was to be a must. And if you search the entire charter for must, there are only 4.
yeah. Well, the answer would be you have to analyze it and read in context. If there is other language,
I have a problem with it being a matter of interpretation, because then it becomes an interpretation of whoever is reading it. And that's 289 interpretations of shall. What I'm going to request is the whereas that changes shall to may be removed from this order. Because this sets a precedent that says all shalls are may. And I don't believe that's what we want to do. And if it gets signed and it's signed by the commissioners, all shalls become may.
Yeah, that's, and especially when we have outstanding lawsuits against the county, does this apply to them too, that all of their shalls are no longer, are just suggestions?
I
first of all,
would be very
first of
helpful. I
all-
would be very happy if we just removed that one paragraph or even the shall to may verbiage, because you sign this and all shalls become may in our charter. Or we have to rewrite our charter and discriminate each one, and that has to also go before the public.
that is completely wrong. That's false. These recitals do not have the force of law. The force of law begins after the words, now therefore be it resolved and ordered. Recitals don't do such a thing. Furthermore, this interpretation only analyzed and applied section 82-29 as stated in the whereas clause that you're referring to.
Can we scroll
But
down?
then
to
again,
that
as I indicate, all these whereas clauses are basically just tell a story. They don't consist or have the value of substantive law. So it doesn't matter to me if you all want, if the president wants to placate you all because you have some heartburn with any of these recitals, strike it, fine, that's fine with me. But I think you're being a little too alarmist on this one recital. I would not say that everywhere you read the word shall in the charter of the town that you change it to may. Every single shall is going to have to be looked at to see if that's the case, using the rules of statutory construction. Particularly, I would say it's limited to deadlines and this sort of thing, in terms of it being a mandate on the town.
Yeah, I think part of my concern about it is we went through 4 years with the federal government and someone who basically, behaved like that laws didn't apply to them. And I think it's a bad precedent to say, well, you're just misunderstanding what the charter says and that we don't really have to do that. Because what's to stop someone else from then going back later and going, oh, well, no, that other section doesn't apply either. And it becoming this, way to get out of actually having to comply with the charter. So I hate to say the whole slippery slope thing, but it's reason to concern about, are our elected officials held to some sort of standard? And appointed officials and whatever else the charter regulates.
Well, I'll give you an example in section 8220 where it says there shall be a board of supervisors of elections consisting of 3 members, or now it's been amended, but that can be up to 5, I believe, with the seat charter amendment resolution that was passed several months ago. I would opine that there's no discretion on the part of the town board of commissioners to devolve itself of a board of supervisors. That would be mandatory. If such a could the board of town commissioners negate or abolish the board of supervisors elections? I certainly have to say no. It would take a charter amendment to do that. There are some municipalities that do not have boards of supervisors of elections. It's completely something handled as a collateral duty by the town clerk. But every provision would have to be analyzed. And this is where I fall in this recital that you're having heartburn with, as to the interpretation of section 82-29, where it uses the shall. I'm not saying nowhere in that whereas clause that applies to every finding of the word shall throughout the town charter. Not at all.
It kind of feels like it says that, though.
No, it's only the ones that
would-
apply to regulate government.
Yeah, I would disagree with that, Patty.
I'm just requesting that verbiage be removed. I don't believe it needs to be there. This is an emergency order and it sets a precedent that has not been discussed ever. And removing shall, becoming a may, or even suggesting it in an emergency order signed by one person on an emergency, I'm not comfortable with it.
Well, based on one person's opinion, one supervisor, with all due respect, the order has already been promulgated. I think it would be a little foolish for the chair or the president to promulgate a new order just to effectuate the removal of that one clause.
Well, if it's one, okay, so the order's out there, but then the board does not have to use the exact same language to set the date of the election, do they? The
Can
Board
I
of
just
Commissioners.
say in here before Kevin answers that, when I spoke with Kevin and we drafted this proclamation, I wanted every legal justification possible to defend my proclamation, because the chairperson of the Board of Supervisors of Elections was threatening to sue the town over the proclamation. So that is why it contains every part possible. So I'm not necessarily comfortable removing things that I was told to put in for legal advice as protection to the town.
Well, it specifically calls out in referring to government when used in statutes or charters. And that's saying the word shall in
Well,
refer.
that's what the Supreme Court of the United States has held.
Exactly. And that's saying that it can be, that every shall in our charter now can be construed as may.
No, it's not what it states. It depends.
It doesn't
has to
say
apply-
that. It does
it has
not.
to-
It
Yes,
doesn't.
it does. It states it only applies, President finds, let's see, where is it? Yes, the president finds it based on a legal opinion of the town attorney, and that's another caveat, be based on a legal opinion of a licensed attorney, the town attorney, the charter provision 8229 stating that in the event a special election is required, et cetera, would likely be deemed directory and not mandatory by the court, the Maryland court, and that unless there is further language to clarify the legislative intent, and that could be recitals as well, the word shall in referring to the government when used in statutes or charters is to be construed as may.
So unless we have language that clarifies, shall becomes may.
Well, it requires that, the cardinal rule of statutory construction is what is the intent of the legislative body that passed the law in the first place. And there's numerous dozens of rules and canons of statutory construction that lawyers and courts apply to try to discern the legislative intent. And there's nothing in the charter to indicate that that would be mandatory, that period of time, particularly during a COVID-19 emergency. I wonder if you would question whether the governor, if he decided to suspend during a COVID-19 emergency, or the county executive, well, that's not going to happen, but if the governor decided to suspend all municipal elections throughout the duration of the COVID-19 emergency, probably has the authority to do that. And I think there's strong argument that the president should be able to do that as well. So
I don't feel like redefining the word shall to may. I don't think the governor would do that to the Maryland charter either.
So, and I think that the special
yeah, I think he would.
election, I think special elections, we have a little bit, there's some different sort of leeway over timing, because one of the issues, there were reports that Donald Trump was talking about postponing the election because of the pandemic. And, if it's this is when you should be, potentially voted out, I think that is much worse than this one, where the town president is not necessarily, their seat at stake. But
well, I think it's a bit futile to compare the federal constitution with the municipal charter as a creature of local government. There's so many differences that it's just not,
But
it's not real handy to compare the analogy of what Trump was doing when he was in office and what we're doing right now under this charter.
But as
again,
you stated, our charter is very, very old. And at the time that shall was used, it was used with the intent of must. If there's that many shalls and that many mays, there was definitely a discernation already there.
and Jay has their hand up.
I disagree.
Just that if, I understand if Patty is expressing her opinion as an individual, if Patty is suggesting that the Board of Supervisors of Elections make that statement, then we need to have that conversation and vote on it. But I think we understand what Patty's individual opinion is on this.
Yes, thank you.
Shall we have a vote then?
A vote to do what now? What would be the
Uh,
motion?
Do I hear a motion to support the argument that shall can be may in certain cases in the charter?
I think that's an insufficiently specific motion.
Would you like to make a different motion then?
Why not Patty make the motion? Patty, what is your motion?
Yeah, I don't need to make a motion.
I'm asking Patty, this is Evelyn. Patty, you should make the motion about this statement here, shall must be, shall is interpreted as may.
I am requesting a motion that that portion of this emergency ordinance either be removed or reworded to remove the shall, may constitute may.
Do I hear a second? I guess I'll second. Am I allowed to second as a chair?
Yes, you can second as the chair.
Uh, All right, I guess I'll do the roll call. Joe Urclay,
Hold on. Chairman, point of order. Can you repeat the
Right.
motion? Can you state the motion for the record?
I was hoping that it was being recorded, so John got it. So my understanding is that the motion is that the Board of Supervisors of Elections would
Recommend?
sure, would recommend that the language saying that shall is not a requirement not
You
be
mean
included.
That shall not constitute the same meaning as may within the charter. I'm just asking for either the removal of that or some clarity.
I think you might want to phrase that you move to recommend to the president that the recital, and go ahead and name the recital or point to the recital, be stricken from future orders or this particular order relating to elections or whatnot. But you all do not have the authority really to give legal interpretation. You can give your own interpretation of what you think the law means outside the recommendation of the town attorney. You can decide that for yourselves as a body, but this is a done deal in terms. You can recommend that she not promulgate. You can recommend that she promulgate a brand new order to strike that recital. But so just go ahead and state exactly what you want the Board of Commissioners or the president to do. That's what I'm asking you to do with your motion.
Can I ask one other question, and maybe that'll rectify it? Does this and everything in this ordinance die after the emergency goes away?
First of all, it's not an ordinance. It's an emergency order.
It says
an
an word,
executive-
I'm sorry. It says emergency ordinance where what I'm in accordance with emergency ordinance, emergency operations.
Oh, we don't see the top of it, but that's not the title, that's the whereas.
Okay,
John, could you scroll up?
okay, so does this order die at the end of the emergency?
It dies within 30 days unless approved by the commission as a whole. And it has to be, notice has to be given to the commissioners, I believe, under the emergency powers ordinance. I believe it's 3 days after the order is promulgated by the president. It has to be shown or notice given to the commissioners that it exists so they can modify, repeal, or ratify it.
And will the public be provided input?
Well, the answer is, if the board cares to examine it and or change it, the board of town commissioners, they can't take actions but in public session. So yes, because of the Open Meetings Act, this would be a matter that they would ratify or approve or modify. Otherwise, it does die within 30 days. It'd have to be approved either as a joint order / resolution or a resolution in of itself by the Board of Town Commissioners. Mr. Chairman,
Yes.
go ahead.
I wasn't making a statement. I mean, it's so the problem is, and the reason that I raised the issue of a lawsuit is there are many parties here and none of us want to violate the town charter. And so it's a question of, by moving the date, is the Board of Supervisors of Elections then not doing their duty to follow the charter? You know, if you know, we don't speak out against these rule changes that seem to be against the charter.
My answer is no. You'd be acting out you'd be in keeping with your fiduciary duty to make reasonable business decisions based on legal advice and the advice of experts. I've already opined on the meaning of that recital and the statutory interpretation of the charter and on the word shall. There's certainly no penalty. I told you the penalty clause in the charter is a nullity because of case law. And as long as you all just like the commissioners, let me finish, just like the commissioners, as long as you as supervisors act within the scope of your duties, and I believe you are, then you're insulated, you're held harmless, you're indemnified by the town. If someone brought suit against the Board of Town Election Supervisors and named all you personally, you would be protected under the town's insurance policy through the local government insurance trust. You would be represented in a case heard before the Circuit Court of Prince George's County for any dereliction of office or misconduct, unless you've acted outside the scope of your duties. I see nothing that shows that you're acting with malice or outside the scope of your duties thus far. Mr. Chairman, this meeting is really going afield here. It's really, you're really belaboring something I think is unnecessary. And I think you all are making many mountains out of molehills.
I thought on Thursday that we had come to an agreement that, you know, we'd have some sort of a statement, you know, that, hey, this is legal for us to do. And if, you know, the town would, you know, make sure to defend us if someone sued us over this, and that we would have an opportunity to discuss the schedule and, you know, the language used, but it's.
I certainly hope to so as well.
I mean, I'm feeling better about it, but it's just, I still have this nagging question of why did this take so long? And then, you know, the agreement not, you know, it got forced through without discussion with us as, so,
Well,
and we have
let's
lots
not
of
forget that the president has the authority and power to promulgate that proclamation. She acted within the scope of her duties and her delegated authority to do that. Scheduling an election is a function of the Board of Town Commissioners and or the president under an emergency to set the date for. So Furthermore, just like other public bodies, including the Board of Town Commissioners, you all have the ability as a public body to close your sessions. And we've been talking about some things that are getting very close to where I'd rather have you go into closed session. However, you've not given notice, I doubt, in your meeting agenda
No, we
that
have
you
not.
might close the meeting. So maybe we should have a meeting in the future to talk about some of these very delicate and intricate issues. But again, I think you're scratching into things you don't need to really get into. And I can assure you, you haven't breached your fiduciary duty if you basically comport with this order of the president of the town commission. Mr. Chairman.
Yeah, I was just looking to see if the order specifically had the language in it that you had cited earlier in the meeting. But while I do that, I noticed that all of the others have their hands up. So I think Evelyn was first.
Thank you, Joe. I feel that we have belabored this point too long, and I have to agree with Attorney Best. I feel comfortable with the fact that we are covered and that the town will support us for the decisions that we make in relation to the whatever we decide, especially by changing the date to February 22nd, if we all agree, of course, on that. But from what Attorney Best said, the president has the power due to this declaration of emergency order to move the date. So now I feel that we should be concentrating on what needs to be done to effect the new election dated February 22nd.
Yeah.
That's
Right,
what I have to say.
and Jay also has his hand up.
I agree wholeheartedly with Evelyn's assessment, and I would like to resolve the motion that's on the floor because we're now going pretty far afield from that motion.
And Patty,
So am I still, hang on, I'm still trying to, because it keeps moving around and I can't see what I'm doing. I am not on mute. Okay, so here's what I'm asking. Oops, I gotta find it again. Where'd it go? Okay, can we end the whereas the president finds where the president finds based on legal? Can we end that where it says and not mandatory by Maryland court and remove everything after the and leave all of that verbiage regarding shall versus may and the clarity and the extra language? Can we remove that piece of it? It still gives you your shall, and it still
Yeah.
talks about not mandatory by the Maryland court. And then it does not go back to discussing specific statutes and charters where shall is construed as may.
so I don't think that we have the power to make that. We can
No,
make
but
a recommendation that we can make a motion that we recommend that
Yes,
the language that you just stated is removed in the final resolution passed by the Board of Commissioners.
yes.
I would, so do I need to have you spell out exactly which language it is again, so that way John can record it for the minutes?
I can say remove the language and that unless there is further language to clarify the legislative intent, the word shall in inferring to the government when used with statutes or charters is to be construed as may.
Okay, and do I hear a second? Then I guess I will second, or Jay?
I was just going to say, I'm pretty sure we already have a motion on the floor that's been moved and seconded. I think that was just clarifying the language of the motion.
Oh, okay. All right, then, shall we, so now that we are going with most recent wordsmithing. Guess we'll, should we have a roll call? John, can you call a roll call for the vote?
Will do. Chair Horkley,
Aye.
Patty,
Aye.
Evelyn Stevens,
Abstain.
John Summerlot.
No,
I don't know. Does that pass? As we did
You
not
don't-
have a,
you do
do
not
not
have
have
a
a majority.
majority.
I have, nope, we do not.
all right. So I guess our other big question is, can we support moot if the election were on the 22nd? So do we need to, I guess Jay still has his hand up. I don't know if that's,
No, I put my hand back up. I do not feel like we have the authority to render an opinion on that. I
Do we
do
at least-
support it as a matter of course, but I don't think that we have the authority based on legal counsel.
do we at least feel comfortable that we can meet our requirements for holding a special election given that date?
Yes.
Is there anyone who objects to that date, I guess I should say?
I'm
Right.
okay with that date, assuming that that we can make the scheduled dates.
I have no.
Yeah, we're gonna,
objection.
yeah, we need to, so I think that we need to make sure that there is notice of the candidate registration deadline and the voter registration deadline as soon as possible, and notice of the actual election date as soon as possible in a newspaper of general circulation of the town and whatever other means they use for disseminating information. We probably need to review what the new schedule exactly is going to be. And that's going to take me a while to draft up. So I don't know if I can, unless we want to pause the meeting and give me an hour to do it, I think it makes more sense to do that at another meeting.
I would agree with that.
Evelyn?
Joe, did not John mention early on the schedule about the announcements early on in this meeting? John?
So he said that the newspaper was on Thursday
Yes.
and they had reserved space for us so we can have we can update the language potentially. They probably have within reason, so long as it's so many words, have something go out on this Thursday.
Right. And then we
Okay,
also
and-
have our constant contact where we will send out on constant contact. We also have sandwich boards that are going to be placed around town tomorrow morning. We also have various Facebook, social media, putting it out there, and on the website. The website's already been updated to reflect the 22nd, if you all decide you want to keep that.
So Joe, what were you wanted some different type of language that you wanted to review, or you wanted to review what John was sending out?
So it in part the deadline for 5 o'clock on Fridays. I would also, was it the absentee ballots request form? There are a lot of documents that we need for the election that need to be reviewed and updated. And I don't know if we can just, assign me the authority to review them, or if we need to have another meeting to review the documents.
Well, I think
to
the
make
first
sure that
thing we should consider would be getting the election, what's the word? We want to get the word out. That should be
yeah,
out.
get the notice.
Yeah, get the notice out, and that should be done by this Thursday. So we should concentrate on that right now. And like I said, we need another meeting Friday to discuss the rest of the things. Let's do that. But the number one thing is to get the word out to the public. And it sounds like John has gone 90.
All right, I think I lost audio again. I heard Evelyn
I said that I think that we should go
say the
forward
number
with
one thing
John.
is, and then it went quiet.
Okay. So what I'm saying, Joe, is that I think John has gotten it together in relation to putting the word out, notifying the public about the change. And I'm sure that we're going with February 22nd for the election day.
That's what it's looking like.
Okay,
Yes,
so
I think
so
no one objected to February 22nd. So
excellent. So then Thursday, John is saying we'll have things out in the public by Thursday. And does that meet the needs, our needs as?
I think that does give us I think it gives us our registration deadline just because it doesn't give it us in terms of the 14 days notice of the 30 days out to register with the county, but people can still register with the town within 10 days. So they're still within the registration deadline for, registering as a voter.
Okay. Okay.
Does
So
anyone
then,
find fault with that logic? And Patty has her hand up, so maybe.
The only thing that I see is candidate filing deadline. It says
Right.
usually 4 weeks.
So there needs to be some compression because there is no way that you can hold a special election within 45 days and give notice of 2 weeks if it's 4 weeks out. I think there needs to be some compression in it, and there is a little bit of wiggle room in the special election ordinance or the special elections part of the charter. Let me find that. I think that's 29. Yeah, yeah, all special town elections shall be conducted by the Board of Supervisors of Elections in the same manner with the same personnel as far as practicable as regular town elections. So I think we have a little bit of slop that we can deal with there.
okay. Okay, so it sounds like we can go forward with John's recommendations.
All right. Yeah, I will, after this meeting, draft up a more complete schedule to try to circulate. John, if you could send me the format that our notices normally go in, so if I need to make any date changes, I can then, more easily pass those back to you and then send them to the board to see if anyone else notices anything wrong before it goes into the newspaper. I assume they probably need it by tomorrow.
It was already turned in today already, because the deadline was today by noon, so that's already been done.
So have you,
Okay, then.
you haven't sent that to anybody other than to the newspaper, John?
Just to the newspaper, but it's also up on the website, just in case you guys, if you were okay with approving it tonight, we would have it there, but we wanted to make sure we get the information out as quick as possible.
Mr.
Because it can always
Chairman,
be changed. We just want to make sure that we were on top of it based upon the DOE that was signed. And we didn't want to delay. We didn't want to delay anything because of deadlines.
Yes, Kevin.
Mr. Chairman, I would like to take leave, if you all would grant it. If there's no other legal questions or legal advice going forward tonight, you're free to contact me. in the future, unilaterally as the chair or as a body. I'd be glad to entertain any questions you have, but I don't want to be on here for another half hour or an hour if I can avoid it.
I have no objections, but I am concerned about the notices going out without the Board of Supervisors of Elections being a chance to review them, as we're supposed to be managing the election.
I would generally concur with that. And I don't know that the town is sending out any other notices separate and apart from those under your auspices as the Board of Election Supervisors.
Anyways, I guess we move on. So thank you, Kevin, for attending. And do I need
Thank
to?
you for having me, and supervisors, thanks for your service to the town. Have a good night.
Thanks, Kevin.
Thank
Thanks
you
a
very
lot.
much, Kevin.
All right, everyone have a good night. Bye-bye now.
All right, so let me go back and look at the agenda again, because at this point, I don't remember where we are. And I have way too many documents open. All right, revise the timeline. That's going to take us too much time to do tonight, so we'll have to, I will send something out for people to comment on, as we're not trying to get everything crammed in by next week. I guess it's gives us a little bit of breathing room. Should we schedule our next meeting to deal with any other schedule issues?
I think so.
When
that
is good
works.
for people?
I'm always available usually after 6 o'clock.
Okay.
Same for me.
I occasionally have meetings on Wednesdays, but for the most part, I'm available after 6 o'clock as well.
Okay. And Yvonne also said that she's busy tomorrow anyway. So is Friday too soon, or should we try for early next week?
I say the sooner the better, but that's me.
I agree. I think we should do the sooner the better. Friday.
Friday's fine.
Okay. Is 6 o'clock okay again, or?
Yep,
Works
it's
All
for
okay by
me.
me.
And hopefully Yvonne is good too. Wish she was here for the discussion, but I will let her know. So we will plan for our next meeting to be what is Friday? Calendar, where's my calendar?
20.
The 21st?
Yes.
21st, okay.
Can you prepare
Yeah, it's a-
agenda for me and make sure I have it in time for the Open Meetings Act?
Okay, I anticipate that part of that will be looking over the proposed, well, the big one will be the schedule, make sure that we know when all of the notices have to go out. I will update and circulate the various documents that we may need to update for dates in case anyone has any comments or misses anything, or I guess John has most of those. So,
Yeah, but just make sure I get an agenda.
direct you, John, to, yeah, I will. Okay. Yeah, I'll write something up. The other thing on tonight's agenda is the review of meeting minutes from the last meeting, but I don't recall if we actually, because there was that mix up of the meeting minutes that I hadn't sent out properly 2 meetings ago. Did we actually review them at the last meeting?
We did speak about them briefly, and I can read a summary of the minutes if you'd like.
Okay.
Joe Horkley and John Hootson did a review of the meeting minutes from December 29, 2021 Board of Supervisor of Elections meeting. Patty Collicott, Evelyn Stevens, and Joe Horkley were in attendance at that meeting. Joe Horkley was made chair of the Board of Supervisors of Elections at the December 29, 2021 meeting. Discussion of items to be stored in the safe. Old and current materials need to be stored. Discussion was held about what was learned during the last election. Town Clerk Hogan advised that Prince George's County Board of Elections is in the process of sending out voter information to town residents. That has actually been halted based upon finding out that we were not having the 25th of this month. Notices need to be placed in PG Post advertising the election. Town Clerk Hogan stated that would be taken care of. Question was asked about current budget. I was going to speak with President Franklin and Town Administrator Carl Snyder. Discussion was held about election schedule, as was on the town website. Candidate packets would be due on January 10th of 2022. Candidate certification order of the ballot, January 11th. Chair Horkley felt that it is not needed. The sample ballot will be placed on the front door as per the town charter. Chair Horkley was concerned that there would be no paper in town hall to start printing absentee ballots. Town Clerk Hotzen stated that there would be paper at town hall. Conversation was held regarding absentee ballots. Evelyn Stevens asked if anyone made any requests so far for absentee ballots. Town Clerk Hotzen responded by stating no. Board of Supervisors of Elections did a review of the absentee ballot request form. Chair Horkley stated he did not receive the absentee ballot request form. Evelyn Stevens stated that she did an initial review and everything looked good to her. Chair Horkley stated that he wanted to modify the document to make things clearer. Town Clerk Hotzen stated the document was sent to the Board of Supervisors of Elections at 4:27 p.m. Patty Collicott stated she received her email at 4:29 p.m. Last dated return absentee ballot request was 10 days before the election, except during the emergency. Yvonne Tucker stated she would hand deliver the absentee ballots if needed, since she was processing the applications. Board of Supervisors of Elections also held a discussion about the safe purchase. Town Clerk Hotzen stated going forward, town committees would be able to make requests for items that are above a certain dollar amount. Patty Collicott asked if a safe needed to be purchased. She asked if a lock cabinet would work. Chair Horkley stated that the town charter states that items must be secure, does not make any reference to safe or fire cabinet. Chair Horkley stated the last two safes were fire safes. First safe was stolen. Town Clerk Hotzen stated that he would do research and reach back out to the Board of Supervisors of Elections for approval on fire safe. Evelyn Stevens said she was okay with the fire cabinet, not necessarily a safe. Chair Horkley asked the Town Clerk Hotzen reach out to the county and get a list of all registered voters in the town of Upper Marlboro for the certification. Chair Horkley stated that if someone comes to you with a candidate packet, accept it. Nowhere does the town charter state close of business 5 p.m. or anything regarding town clerk. If nobody turns in candidate packet, election goes to a full write-in election according to Chair Horkley. Candidate packets will be scanned to Chair Horkley. Board of Supervisors elections will meet at Town Hall on Monday, January the 10th at 5 p.m. to work on candidate certification. Yvonne Tucker made the motion to adjourn. It was seconded by Patty Collicott, and the votes were 4-4, and the meeting was adjourned at 7:06 p.m.
All right, thank you. Any changes or? Okay, hearing that, do I hear a motion to approve the minutes?
I motion to approve the minutes from last meeting.
Do I have a second?
I second.
All right,
Joe,
all in
while we're
favor?
here. Oh,
Yep.
sorry, go ahead. Aye.
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 And I believe that was 4 ayes.
Do we want to review the minutes you sent out as well, Joe?
Yeah, I think what happened at the last meeting was that I did it from memory as opposed to actually going over it. I think I didn't find it in time before the meeting and then sent it out afterwards. So the December 29th meeting, the attendees were Evelyn, Patty, and myself. We opened the meeting at 7:17 p.m. We had to change the agenda. We changed chief judge to chairperson. For the appointment, Patty nominated me, Evelyn seconded. We were all in favor. I suggested that we need to look into making it once per election and not per term, as people may not have the flexibility to deal with a special election, and made a comment that this is the chairperson. This is not necessarily the chief judge the day of the election, as that can be delegated. For communications, we discussed how to best communicate with people, and we said email, but you should send a text to warn people to make sure that they see it in a timely manner. And Patty mentioned that the historical committee has an A-frame sign that we could potentially use for election info also. We had questions about, we discussed the schedule. There was a question about, are the requirements in calendar days or business days? And the decision was made that if it was less than 10 days, requirements aren't us, should be in business days to try and move those forward. If it was a requirement on the citizens, we should treat those as calendar days so they have as long as possible to comply. There was the question of what qualifies as a newsletter for giving notice. And we weren't sure if either the landings or if, next door somehow qualified. We, in the reviewing of the schedule, we did move or we added the town meeting and setting the ballot order date. And we moved the deadline to post the sample ballot forward. So that way it was 4 days with, not including the weekend that would be there. So, and there was the mention that we needed to get everything to the newspaper immediately. We had a discussion about what needed to be stored in the safe. The consensus was 1 current election plus 1 past election. And for now, we would just plan for 1 voter card box, even though that may increase as we annex. And so that set the how much space we needed to allocate, which I don't have here. And then I would determine what safe models to look at based on what was available quickly through the vendor in town. There was also the question of maybe there was a second combination for the old safe, so maybe we still had a chance to be able to get into it before we ordered a new safe. There was also discussion of should we deal with security seals? And the discussion was yes, because if we have 2 election materials in there, we can then seal the past materials to be sure that, they have not been tampered with while we have the other election ongoing. Or dealing with absentee ballots and such, but not having to worry about other changes. For our lessons learned, we discussed we needed to clean up the absentee request form because multiple people missed the fact that there was a signature blank on it that they had to sign. Verify that we can get into the safe before the election. We probably need a policy on who deals with absentee ballots. In the past, sometimes it's been done by the town clerk, sometimes it's been done by the election people. There was a question of, do we need to make sure that 2 people are handling the ballots at all times? Do we need that just for voted ballots, or should that also apply for unvoted ballots, which would then affect absentees? There was a recommendation to update the charter or ordinance for special election deadlines because some of them are in terms of calendar, like, what month it has to occur in, and, try and make sure there's knowledge about how to set the schedule. And do we need to schedule breaks so no one's working 14 plus hours in one day? And that I would post the election procedures that I had written up so far on Google Docs. Patty made a motion to adjourn, Evelyn seconded, and we adjourned at 8:40. So any corrections to that one?
Sounds pretty good to me, Joe. Very thorough. You did this from memory?
No. I found my notes this time.
Okay. I think that was pretty.
I sent them out. I sent them out right after last election. I can send them out again just to make sure everyone has a copy.
Thank you.
All right. Do I hear a motion to approve that set of minutes?
Motion to approve the meetings from, what was it, December 29th?
Yes. Do I hear a second?
Second.
Thank you, Jay. All in favor?
Aye.
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 Aye. And that is 4 ayes. Okay. Any other, next on the agenda, any other election logistics that we need to deal with?
I think we should put that on Friday's agenda.
Okay. I concur.
I agree.
Any objections?
I
Nope.
agree.
All right, hearing no objections, next agenda item is adjournment.
I motion to adjourn.
Second.
All in favor?
Aye.
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 Aye. And that would be 4 ayes. Thank you, everyone.
A nice evening, everyone.
Have a good night.
Good night, everyone.
Right.